I know you've all been waiting for it. This is Lunch with Johnny Depp's attorneys, Benjamin Chu and Camille Vasquez, hosted by the president of the Beverly Hills Bar Association, Anthony Ross. I hope you all enjoyed today's program, and over to you, Anthony.
Thank you, Chelsea, for not only a wonderful introduction, but for reminding me of the wonderful support of our members, and also the importance of Beverly Hills Bar Association in helping to support the next generation of attorneys. Now, whether you're watching us on Zoom or on YouTube, welcome. Welcome to Lunch with Johnny Depp's attorneys, Benjamin Chu and Camille Vasquez. I'm Tony Ross, president of the Beverly Hills Bar Association. I'm very grateful for that today's guests could join us. And so thank you both. I am just going to launch right in. We have not much time, so I just want to get as much as we can get. So first person I think I will ask Ben. Ben, when you got into litigation, did you ever think that you would be representing A-list celebrities, or was that really your goal to do entertainment law?
Tony, first, thank you very much for hosting Camille and me. It's a great honor to appear with you and before your wonderful members. No, I have to be honest and say it was neither my expectation nor my aspiration to represent A-list celebrities. I was just someone who was very interested in litigation, and I just fortunately had the opportunity to represent. First, I represented Cher, and then I had the opportunity to represent Johnny, which has been a great honor and a pleasure.
When you represented Cher, what was that first meeting like?
The first meeting was a little bit nervous-making. It actually was not a direct representation of her, but a representation of a pro bono client in Virginia. It later became the subject of a documentary called Edith and Eddie. It was a love story of an elderly couple. Cher had heard about this couple on the news. Ironically, she heard about it on the Los Angeles news, but it was a couple who lived right outside of Washington. And one of them needed legal representation. And through a friend, she contacted me, and I agreed to, of course, do it pro bono. And that was a very rewarding representation.
Wow, nice. Camille, can you tell me how life has changed since you've taken this case?
Well, I think life has really changed, but some things have remained the same, right? I mean, I'm obviously very close to my family. I enjoy doing legal work, good legal work. I enjoy working with my colleagues and especially Ben, obviously. And but life has become a little less private, a bit more, I feel like there's parts of my life now that I have a responsibility to share with fans or people, especially young women that have come forward and said, thank you for being an inspiration, and thanks for getting me through a hard time or pushing me to go back to school. And I feel a huge sense of responsibility to them, and to continue doing good work and be a source of inspiration for them.
When did you know, Camille, when did you decide that you wanted to be a lawyer?
I mean, I feel like the decision was sort of made for me. I joke. I come from a Hispanic background. My mom is Cuban, my father is Colombian, and they said to my sister and me as we grew up that we were going to be professionals, right? That they weren't going to leave us with a lot, but our educations. And so they said, you get to be a doctor or a lawyer, so pick one. And my sister became the doctor and I became the lawyer. But I wasn't particularly great at math and science, and like a lot of lawyers that are afraid of Excel spreadsheets or math. Right. I felt like the arts and the liberal arts were much more in my wheelhouse. So I probably really started thinking about it seriously in high school.
Yeah, I'm one of those who can't do math and science either. And yeah, that's why I think I ended up, although I love it as well.
Yes.
Ben, Camille just made me think of something. She mentioned that, the arts, and, they often say that a lot of what we do, trial lawyers in particular, is you're putting on a show. Ben, do you agree with that? And do you have examples of how you do that?
I completely agree with you on that, Tony. And one of the things in planning this trial, which ended up being quite a long trial, at least by Virginia standards, of 6 weeks, we thought that we needed to not so much entertain the jury, but to tell them a compelling story. So we gave a lot of thought. And again, I give Camille and others on the team primary credit for this. They were thinking thematically and how best to put the story in a compelling way. And I think one thing that we decided early on was to kind of begin at the beginning, to tell something about Johnny's story, to tell them enough about his life growing up that they could better put into context his story about the events at issue in the case, because they really had a bearing. His background had a real bearing on how he reacted to things that happened in his relationship with Ms. Heard. And I think we were able to, the witnesses were really able to kind of set the table. So by the time that Mr. Depp started speaking, I think the jury was prepared to understand the context.
Got it. I guess I'll throw this one to Camille. I often say that movies and television do us a disservice because they make trials, look like they happen in 2 or 3 days, and everything happens quickly. This was a long trial. Do you think, Camille, that it was instructive for the layman who was watching? Do you think that cameras in the courtroom, for example, are a help?
I think they definitely can be, right? I mean, it's another factor that we as trial lawyers have to consider when preparing the case. But I think it's definitely instructive and educational. I had a lot of people have approached and said, I now know what lawyers do, and I know what you do. I know I've had also people say, parents that are lawyers say, oh, my kids finally sort of understand what I do. They've asked like, hey, Dad, what's objection hearsay mean? Or what's objection relevance mean? And,
right.
and I think because of the trial, people took a real interest in what we were saying and what was happening and why the court was ruling in certain ways. And I think it was a crash course in what trial lawyers really do for a living.
Thank you. I agree with you. Let's see. It doesn't matter who answers this question. I'm just curious. So I recognize, social media became a thing. It really around this case. I mean, that's happened before. It really just becomes a force unto itself. Did that so much attention on social media? Did that make you pivot the strategy at all? Did it have any effect on how you guys were approaching the case?
No, I mean, I don't think so. We really lived in a bubble during the trial, and we have no reason to believe the jury acted in the same exact way, right? I mean, we had a job to do. We had very little time to do much of anything but work. And that time that we did have, it was to sleep. I do think, though, that, we started noticing that this was kind of taking on a life of its own, probably midway through the trial. Our hotel was attached to a mall, and I went to grab a coffee one morning over the weekend, and this sweet young girl with like braces, said my name and then handed me my coffee, and she looked at me and she went like this in like the cutest way. And I thought, oh God, do I have something like on my face? And then she said, "You're Johnny Depp's lawyer." And I was like, how do you know that? So, but no, it really didn't play a role in our strategy at all. I mean, obviously the fact that there were cameras in the courtroom, that was something that we knew, but I don't even think that played much of a role, at least in how we did our jobs. I don't know if Ben feels differently.
No, I feel the same way. And I was mortally afraid of hearing the critique of any of my performances. So I stayed away from it. And after a couple of weeks, it's not that we forgot them, but we really didn't. As you know, Tony, as a trial lawyer, you just don't have time for a lot of things other than what you have to do. So we just kind of moved ahead.
So now that you know, now we've had this example, right? So in the future, for your next high profile case, do you think it will that color any way that your strategy is created, do you think?
Ben, do you want to take this one?
Sure. I think if we knew in advance we'd have another televised trial, I think we would do. I mean, obviously, we would always do things differently because we could always have done certain things better. But I think the approach to try to do it thematically and to try to tell a story is something that we would probably do again. I would just hope that we had the same team.
Right. Speaking of that, how do you pick your team? What criteria did you use to pick your team?
Well, I'll start out because Camille chose a lot of the other members of the team. But when this case started out, it was just a core of Camille, myself, and another attorney. My rule on this case was that anybody who worked on this case had to be materially smarter than me, which is a fairly low bar, and they all cleared that bar. But beyond that, we really chose people with whom we not only respected as lawyers, but whom we respected as people. In other words, people we could get along with, people who had high character, who had a sense of humor, because we knew this was going to be extremely difficult. And although we each brought our own different perspectives to it, and we tried to have some doubters among us, and we did. We had two we called Eeyore because they constantly told us we had no chance to win until about the middle of the trial. We did think it was important that the people who worked on this case believed Johnny, because we fervently believed him, or we would not have recommended that he file this case. As you know, Tony, defamation cases are inherently difficult. Truth is a defense. So, I mean, obviously, all of us do due diligence before we file any complaint for Rule 11 and other reasons. But defamation cases, as you know, you have to be particularly careful. So by the time, Camille and I and a couple of the others who were on at the beginning, we were true believers in the sense that we'd really looked at all the evidence and we'd done a lot of hard digging. And it was important for us to have others who were of like mind and who were willing to, we knew even before we knew it's televised, that there might be some criticism. We were kind of running against the tide of Me Too, which, by the way, all of us, including Johnny, support. And we also understand that the vast majority of victims are telling the truth. But as Camille likes to point out, and she'll say it more articulately than I do, there's also a notion of due process that we all have to remember, especially when, we're dealing with controversial subjects, that you have to just kind of wait. There's plenty of time to judge after the fact. So it was important for all of us, to be kind of like mind in terms of how we interacted with each other, and that we had a belief in the client.
Makes sense. Camille, did you want to add anything to that? How do you pick your strategy?
I mean, I think that I echo Ben's thoughts on this. I mean, for me, it was important to have a young team. I thought that we were dealing with issues that resonated with young people. And I thought that in some way, as maybe as counterintuitive as this may sound, is I think sometimes less experience motivates people to really throw themselves into a case and over prepare and dig into the facts. And that's what happened in this case, right? And we gave opportunities to young lawyers that had never necessarily taken a witness before. And
I can barely, your sound went out a little bit. Sorry.
Okay. Can you hear me okay now?
It's not, I can still hear you. That's all right. Keep going.
Okay. So we gave opportunities as much as we could to young lawyers because we thought that A, they had earned it, and B, if they had one or two witnesses, they were going to work really hard for those one or two witnesses and knock it out of the park. And they would know everything, every pitfall for that witness. They would know exactly what type of evidence to elicit that, worked with the theme, and how to prepare that witness. for cross-examination. So I think they did a phenomenal job, and that was important to me, is to have a young team looking at this from different perspectives. And yet Ben is correct. We all believed Johnny. That was the one requirement, right? And it goes without saying that that was incredibly important in this case. And we did. We all believed him. We believed that he did not do this, and he was, in fact, the victim of domestic violence. And we just needed to convince this jury that that was the case.
Oh, thank you. So Ben, you mentioned, you know, a little bit about if you got the same type of case, you do things differently. What do you think you would do differently?
Well, I think I think we probably would have gotten more of these great young lawyers involved earlier. I agree with Camille. I think they did a phenomenal job. I think it was more interesting for the jury to see different lawyers do different things. I think the judge appreciated it because it was, judges, as you know, tend to like younger lawyers. They don't want to just see the two partners, you know, getting up and snapping their fingers and asking for documents. I mean, that's not the way this team was. And I think it came across well. So one of the things I think I'd do differently is to get those lawyers involved in depositions earlier, not just say scripting it out for Camille or Jessica or me, but to get involved earlier on. So that's one thing I would do the next time.
Okay. Is there, Ben, then Camille, is there something in the trial process, in the trial prep process up until trial, is there anything that you about that you hate? Like there's just one thing you just do not like when you have to prepare?
Maybe Camille could go first while I think about that. That's a great question.
Can you hear me, first
Yes.
of all? Yes.
I can hear you.
Good. Okay, great. There's something that I don't like about the process, the trial process.
Yeah, like just of all the things that we have to do, is there one thing you're like, okay, somebody else do that? That's the one thing I really don't like to do.
Oh yeah, discovery. It's the worst.
Really?
Discovery and discovery disputes. It's the worst. I mean,
Yeah.
I don't know that you'll find a lawyer that says, oh, I love meeting conferred with the other side, or I love writing discovery motions.
Now, I'll give you that. I don't love discovery motions. I really do love discovery. I'm weird that way. I like discovery a lot.
I would say deposition designations, and I exercise prerogative as the old guy on the team that I had. I asked Camille to supervise the young attorneys to argue the deposition designations. And in this case, and I don't know, I don't really know how it works so well in California, but in Virginia, usually the judges don't give a lot of their own time to that and expect the lawyers to work it out among themselves, and they give it short shrift. In this case, the chief judge gave us a lot of time. So she would reserve each Friday, because virtually all of Ms. Heard's witnesses, other than her experts and her sister, were done by deposition. So it was a big part of her case, less so of our case. So it was very important. These were crucial battles that were played out every Friday, because Friday was an off day of trial. And that's something that I found tedious and really required a lot of attention. And Camille and the young lawyers really fought it out tooth and nail. And it was really important. And I think that was, if not dispositive, I think that was really important because, and this is kind of a dominant theme, they really had two lawyers doing almost everything. They had a team of competent lawyers. They had lawyers who could have done more. But for whatever reason, and maybe it was a client imperative, we don't know, it was pretty much just the two of them. And they both were very good, but they were getting worn around the edges. And it showed. I mean, not in closing. Of course, you're going to have your energy for the closing and the opening and the big witnesses like, you know, Amber and Johnny. But at things like deposition excerpts, you know, the partners were kind of made fun of me when I was just bringing sandwiches to the team when they would do those arguments. But I think they envied me by the end of the process, because for me, it was kind of a day off. And that's something I found tedious, but I think they did much better than I would have done. So I think it's really important to utilize the team you've got. And they want to do it, and they will rise to the occasion. If you've chosen wisely, they will rise to the occasion.
It looks like all of yours did, really. You guys had an impressive team. Camille, what's the funniest thing that ever happened in a courtroom?
In the courtroom?
Not necessarily just this trial, but in a courtroom, what's the funniest thing that happened?
Oh, well, I think this trial had a lot of examples of that. I mean, everything from Johnny using his sense of humor and showing everyone his legal knowledge. You know, he would object to questions before we would, or, you know, he would say, oh gosh, what I'm about to say is that must be hearsay. I mean, there were some really funny moments. There were some interesting witnesses, not to name any names, but there was one in particular, the other side, an expert that was bizarre and comical, but yeah, I mean, there were some really funny moments, and of course some inside jokes that we all shared. I mean, right. I'll let Ben share this one, but Ben, we got a mascot, right? That was our team mascot. And let's just put it this way, our team mascot infiltrated the other side's closing arguments. I'll let Ben explain that, though.
Ben, please, I gotta know what that's about.
Well, the alpaca, shortly after the op-ed, Ms. Heard's op-ed was published, Disney let it be known that they were dismissing him from Pirates of the Caribbean. A reporter called Johnny or accosted him and said, would you ever come back to Disney if they apologized to you? And he said, and I'm paraphrasing, not for $200 million and 100 million alpacas. So one of his fans each day brought to trial, didn't get into the courtroom, but outside the courtroom brought 2 comfort alpacas. Now, I never knew that there was such a thing as a comfort alpaca, but apparently there are.
I'm just learning that now. So
it was, it became the mascot of the trial. And someone gave me a miniature alpaca, which I ended up, I had in my pocket during an argument. And the judge's senior law clerk said to me during the break, you know, you had an alpaca in your pocket. Said to her, I hope you didn't rat me out to your boss. And she said, I didn't, but you really should be careful next time. So what Camille was alluding to is we had, for closing argument, the way the courtroom was situated, there was an enormous lectern that was about a mile away from the jury. And I had used that for opening because I didn't have Camille's courage. Camille went right in front of the jury, which is the way you're supposed to do it. But I knew that was not workable for closing, which we were going to split. And because we were so busy, we couldn't memorize the closing. We had the dilemma. Do we want to be before the jury just with a big stack of notes, which is kind of awkward, or do we want to, seek protection behind the big podium, which would look like we were afraid and not believing in ourselves? So I found a tiny little podium that had belonged to my mother. It was an encyclopedia holder. So I found that, I brought it in, and I put the little alpaca in the little drawer for good luck. So Camille and I both used the podium to our great advantage. And then, unfortunately, one of Ms. Heard's lead counsel, Ben Rottenborn, he took advantage of it. Before I could take the podium away and force him to make that Hobson's choice, he seized the podium. And to my horror, he used it to great effect. And to throw him off during a break, I said, there's an alpaca in there. And he gave me stink eye. So we had a little humor there. But as Camille said, there were Johnny had some great lines in his direct that we hadn't anticipated that were just quite, when the other side would say, well, did I read that correctly? He would really undercut it by saying, you read that quite well, Mr. Rottenborn. So he was able to disarm opposing counsel without being snarky or without being disrespectful, which, as you know, is not what you want your witnesses to be.
Yeah, he's, you know, it's funny. I thought of the two of them. They're both actors, right? I was watching, she would look at the jury in a way, I don't know if that was something that someone had told her that she should do, because sometimes that actually works if you look at the jury. But the way she did it did not seem to resonate to me, and I wondered if it resonated with the jury. But that's all these different little strategies. You mentioned Camille, and did I read that right? Camille said that a lot. Every time she said it, it sounded sincere. And I don't know if the other side was trying to use that to, you know, use her strategy for themselves. But it's funny, and again, same thing. You said you wanted to use the podium further away. She wanted to use the podium closer. All those little strategy points are, I think, what makes a really good trial lawyer, because you have to know you can't do the exact same thing that someone else does. It doesn't work. You have to find your own, what makes you you, and then give that to the jury. Do you see that yourself, Ben?
Yeah. Oh, I think, Tony, that is spot on. I think that is such a great practice point, because you can't emulate somebody else. You can pick up certain things. Oh, Tony did this really well. I can try to fold that in, but you know, I couldn't possibly be you. And we all have our own strengths and weaknesses. And I completely agree. And that goes for the younger attorneys as well. They're going to do things a little differently than you do. And, you know, that's probably a good thing, you know, that the jury is seeing different things. And we tried to do that in terms of subjects. For example, for closing, Camille had done what I think was just an outstanding cross-examination of Ms. Heard. And I think, of course, I'm biased, but I think she came across as not mean and not trying to vilify her, but just using her own words and getting her to explain that. So we thought, for example, in closing, Camille had handled Amber, and she should address, you know, those points. And for me, my job in closing was to try to explain to the jury what Johnny had lost. And he's a lot younger looking than I am and a lot better looking, but we're about the same age. And I can't pretend that I understand his life, but I've had some experiences common to him. And I can imagine, at least in part, what it would be like at his age to lose a career and to have his children have to, they never believed it. It's not like they believed their dad was a bad guy or done any of these things, but to have their children have to go through life with this stigma. So it was my job to try to convey that in closing to the jury. So I was less kind of focused on some of these gotcha points, and it's more than gotcha. I mean, you know, the merits, as it were, but to try to put it in terms, not in dollars and cents, but what this man had lost and what was at stake for him, which was to get his life back.
Right.
So we gave that a lot of thought, and I think Camille could have handled that, you know, beautifully, but we were trying to figure out which one of us would handle certain things better.
Thank you. So Camille, in terms of how you connect with a witness, have you ever had a witness or someone you really couldn't connect with, Camille, that you really kind of had to try to find your footing? Maybe they were much older than you or for a different background?
Of course, I think that's part of being a trial lawyer, right? You have to adjust, right? You have to course correct. I think that something that gave us an advantage in this case was, you guys can't hear me. I'm getting lost down.
I can hear you, but I can't hear you as well as I can before.
Okay. I might switch to audio on my phone if that's easier, but
okay.
Can you hear me okay?
Yes.
Okay.
Yeah.
Okay, so I'll just answer this question and then I'll switch to audio on my phone. I'm sorry.
Yeah. No problem. Just
Needs
like course correct, we'll work with it.
Yeah, we're course correcting. So what I was saying is, I think something that gave us an advantage was we had a really interesting deep bench of attorneys that we could pull from. And my job really was to try to put certain witnesses with certain attorneys. And it was about chemistry, and it was about, making sure that they had something that made sense. And that's why I put certain attorneys with certain witnesses. And but for me, yeah, absolutely. I mean, I did the cross-examination of Amber Heard's orthopedic surgeon that opined on the cause of Johnny's finger injury. Obviously, I'm not a doctor, and I'm not, a distinguished doctor, and that's not my background. And we just talked about how science and math aren't necessarily my forte, but I focused in on, as a juror, right, not having necessarily a medical background. How can I explain my point to the jury? And I think that's the best way to do it. Yes, sometimes you're going to have a witness you can't find the right rhythm. You can't find anything in common with them. And it's about just focusing on, to me, what the jury is hearing and listening to, and communicating that.
Okay.
Yeah, and I would just add, Tony, that that's why you say you love discovery, and I do too. And that's one of the ways where you can kind of make that assessment. I mean, for example, we had 3 days of deposition of Ms. Heard, and she had 3 of Johnny, because Virginia doesn't have the 7-hour rule. So we negotiated a 3 days. So we also tag teamed it, where Camille took 1 day, I took 2 days. And clearly Camille was much more effective eliciting information from Amber than I was. So to me, it wasn't a very difficult decision, which we collectively decided that Camille would be doing Ms. Heard at trial, because I mean, it was objectively clear that she was more effective with that particular witness. And if you have discovery, of course, you've got the luxury of doing a postmortem and looking in to see who elicited what. It's harder, obviously, on rebuttal witnesses where you haven't had the opportunity. And one example, to those of you who saw the trial, was the TMZ witness, the witness who came on, who testified to the effect that the paparazzi had been tipped off in advance of Ms. Heard's ex parte TRO hearing, which was very a powerful testimony for Mr. Depp. And Ms. Heard's counsel hadn't had the luxury of taking his deposition. He was a rebuttal witness. So that's kind of an example, Tony, I think, of what you're talking about. And she's a very skilled attorney, but she had a world of trouble with that witness. And, he really got the best of her. There was one question where she accused him of, well, aren't you just appearing at this trial to have your 15 minutes of fame? And he turned it around and said, well, I could be saying the very same thing of you. So it goes to your point. You don't always hit it off with certain witnesses.
Right. And I mean, he was masterful. That's what I was saying about intuition as an actor, I think. I mean, Camille had mentioned this, those exchanges about when he figured out what hearsay was. Those were really, I mean, those were genuinely funny moments. And it didn't come off snarky. It made him, it endeared him, I think, to I assume the jury, because it definitely endeared him to me, and I'm just watching from a distance. So, are you superstitious at all when it comes to trials, Ben?
Yes. And I was very superstitious when I had a friend of mine who's a very senior lawyer in Washington, and he said, "You're winning." And I said, no, don't say that. Don't you dare say that. We're playing from behind. We have no chance of winning this. No, I don't want to hear anything like that. And when anybody started to sound optimistic, I would turn the other way.
Camille, is Camille, are you back with us? Can you hear us, Camille? Well, we'll just wait for her. But then, so all right. So you're superstitious about that. Is there a type of law that you were also interested in, and you didn't get to do? You went in this direction, but was there anything else pulling at you that you almost thought you were going to do?
Well, out of law school, I had the notion in my head that I wanted to be an international trade lawyer. I had visions of, crossing the globe and, kind of a James Bond lifestyle. But I actually practiced international law in Washington for some very nice people for about a year. And I realized it really wasn't. It was very technical. It wasn't really at all what I expected. And by luck, because I speak some Spanish, I was brought in as a very young associate to a case between Standard Fruit Company, a California company at the time, and the Sandinista government of Nicaragua. So that was really an exciting case. We got to go down to Nicaragua and take depositions of comandantes. And I thought, gosh, litigation's the way to go. I mean, you're traveling. It's exciting. There's a mild patina of danger without any real danger.
Right.
And it's a lot of fun. So I thought that was when I really got the litigation bug. I mean, I'd done moot court in law school, but I really wasn't committed to litigation until that. And I have really loved it ever since.
Can you hear me now?
Oh, yes, we can.
Yay.
Hey.
Okay.
So Camille, I'll ask you what I'd ask Ben. I see where you are, the type of practice that you have now. Was there something else pulling at you, or is there something else pulling at you, another type of law that also captures your attention?
Yeah, I mean, I think a lot of things capture my attention, right? I mean, as a trial lawyer, both Ben and I really strive to be generalist. And, but obviously we're getting a lot of potential cases that are either defamation in nature or Me Too cases, if that's how you want to look at them. But I think that's something that's really true for both Ben and me is that, and our team, by the way, that is about due process, right? And it's almost, instead of anti-Me Too, it's what I would call maybe anti-cancel culture. And
Okay.
It's about, making sure that there is an investigation and that there is due process before someone is canceled. And we take that really seriously. And I think Johnny's case was an example of exactly that. So as journalists, we're interested in a lot of cases, and we just want to do good trial work.
Nice. Camille, I'm going to pivot a little bit. I want to ask you about being Latina and being a woman in this profession. As you can imagine, you don't have to imagine that you live some of the same circles I do. A lot of people don't look like me when I'm going to court. And the same can be said to you. How do you think the profession is holding up in terms of its ability to, add diversity, or at least invite diversity, and really kind of broaden the practice to a lot more different types of people?
Well, I think it has to, right? And I think it's happening. It's a great time to be a woman. It's a great time to be a minority. Juries are diverse, and companies and individuals are realizing that they want different people that look more like their juries on their trial teams. And so I think it's a great time in the profession. Obviously, it hasn't historically always been as easy. But I do think that some advice that I give to especially women, right, young women, is you just have to prepare more. You have to be the most prepared person in the room, because you will be challenged, and you have to be able to have the confidence to respond. To do that, the way that I have found is through hard work and being the most prepared person in that room.
I think that's good advice. If you had children, I don't think you do. Do you have children?
I do not.
If you had children, would you encourage them to become lawyers?
It depends on the child. I think, look, it's an incredibly rewarding profession. And I from a young age, I think I was meant to be a lawyer. I was meant to be an advocate. I have a funny story. I was young in elementary school, and I felt that the lunch ladies weren't being very nice to the kids. And I made it a point to call for a meeting with Miss Alice, who was the head of the lunch ladies, and try to mediate some type of deal, right, where we would behave better, but they would behave better towards us and not yell at us. And I thought lunch be a time of it shouldn't be stressful. And I was so stressed out going to that cafeteria because these lunch ladies were just yelling at these kids, and I just thought it was wrong. And so I had to stand up and I called for a meeting, and they were actually really receptive. I mean, they probably thought I was ridiculous, like little 7-year-olds, but it was important to me that everyone treat each other with respect and not, be pejorative just because we were young kids. So I think I've always been a natural born advocate, and ever since I could speak, it was something that I was meant to do.
Wow, 7-year-old. Okay, interesting. So Ben, let's ask you the same question or something similar. When you were young, maybe 7, when do you remember your first examples of you advocating?
I don't have anything as compelling as Camille's story, but I did do that, and now I'm worried about my own kids. I'm an older father. My kids are 10 and 11, and I was hoping that they would do something different. But my youngest was at overnight camp a few weeks ago, and he complained that he wasn't allowed to have seconds without eating his vegetables. So he started, like Camille, he started a movement at his camp called Kids Against Cantaloupe, which was unsuccessful. Fruit and vegetables continued to be served, and it continued to be a condition before he got seconds. But now I'm worried that he's going to be a lawyer as well.
That's funny. And that's why I actually asked that question of Camille, because it's almost like to a person, lawyers don't want their children to be lawyers. Tell me why that is, if you have an opinion on that, Ben.
I think it's very hard profession. I mean, I really enjoy it myself, and I'm older, so it was a little easier when I was coming up, because in those days, if you were a good lawyer, meaning if you worked hard and you did everything right, you could have a pretty, well, again, that's coming from my background. My background's easier, not having been a minority. So I get that. But, and it was harder, obviously, for people of color and for women, when I was coming up, and still is. But I think it's harder now, in the sense, if you're talking about private practice, because now I think young lawyers, fairly or unfairly, are looked at to have a lot of business. And I don't know, as a 30-something lawyer, how many 30-somethings are in a position to have a lot of business, because their peers are not, general counsels. Their peers are not yet higher in the corporate hierarchy. And I just think the pressures are I think it's not just enough to be a good lawyer. I think you have to be a good lawyer plus. So I think it's a harder life. I don't mean to be a downer, because I think it's still a great profession, and there are many opportunities, not just to go to a law firm. Many other ways to be a lawyer. I have friends of mine who are great judges, but I think it's hard. I think that's why maybe, Tony, some of us aren't encouraging our kids to go into that, because I think it's not so easy.
I would agree with that. I always tell people that if you're called to it, do it. If you're on the fence, it's hard to do if you don't love it. Did you learn anything from opposing counsel? And I don't mean anything like techniques, tactics, something you've not quite seen someone do before, or at least to good effect. If not this case, can you think of a case where opposing counsel, you really kind of learned something?
Yeah, I mean, I can tackle that, and then Camille will probably have a better answer. I've learned from. I remember early in my career, I had a case against an attorney who was not from the greatest schools, and he didn't seem to be as bright as some other attorneys, but he was very effective, and he won the case. He told corny jokes, but they were authentic. Kind of, Tony, it goes back to your point about being yourself. He was himself. He was very likable, and he may not have been quite as book smart as somebody else, but he was very likable, and he was very smart as to what was really important about the case. And by contrast, not naming names, I've seen attorneys who are very sharp, but who don't hesitate to show that. And they need to show that they're the smartest person in the room, but that's not always the most effective attorney, as you know. My father told me something I'm not sure I learned, but he would look at me sometimes and say, Ben, you need to learn the value of the unexpressed thought. And that's, if you have it's good in your personal life too, but you might have a comment that might be witty or something, you want to say to your wife, but it's just not a good idea. And I think that's true in the courtroom as well, that it's not necessarily who the smartest is or who the smartest thinks he is. It's, you want to be human. And I've learned that from people in court, that sometimes you just need to let the jury or the judge make that final leap, and again, I think Camille did that a really nice job, in the course of Ms. Heard's cross-examination. I don't think she tried to go for any knockout punch. She kind of made her point and moved on. And I think that's really important in cross-examination. You don't want to make yourself unlikable.
That's true. Camille, same question. So have you, either in this trial or another one that you can think of, did you get to learn something from opposing counsel, something that you realized you might incorporate or at least be aware of?
Yeah, absolutely. I mean, I think that trial is so unpredictable, and we all know that as trial lawyers, right? And you have to be able to course correct. You have to be able to pivot. Not everything is going to go your way. And if there's something that I learned, is you have to plan also for things not to go your way, so that you have a solution in place. You should think worst case scenario. I'm going to get every objection. I'm going to deal with a witness that's going to be sympathetic. How do I handle that when that situation arises? And I think something that we did quite well as a team is we were able to pivot. And I'm not certain that the other side was so effective at that. And it really surprised me, if I'm being honest, that such experienced attorneys didn't seem to be able to course correct and pivot. But it's a lesson, I think, for all of us, because yes, the case went our way and the verdict speaks for itself and it was definitive. But we had bad days too, and it's about how you course correct.
What would you say would have been was a bad day?
I think there were days where there was, evidence coming in where Amber was putting on her case in chief, and we knew that the evidence was going to be contradictory to, Mr. Depp's version of what occurred. And so it was tough to be able to help the client understand that this was just part of the process, right? It was tough to hear this evidence that we thought was false. And it's discouraging, right? And it was hard to get. We had one of our experts that wasn't allowed to testify. That was really disappointing for us. And, but it's about how you deal with it and how you keep it moving forward and keep the client engaged, keep the client on the same page as you, and understanding that this is just all part of the process.
That's, I think, a good point. I think one of the things that and it happens more in your, if you're a plaintiff's attorney, I think, at least it feels like it does. clients don't know this process. And I find they get very frustrated when they're confronted with it, because again, that's why I say TV and movies do us a disservice. Ben, how do you convey what is about to happen? Or, when you have a client, this was a very long trial. Johnny's, he's worldly and experienced, and he probably got it better than many others. But how do you prepare a client for this journey?
It was hard, and this case went on longer than most in Virginia because of COVID. We had the trial was delayed twice because of COVID, and once because our first chief judge retired. And that really caused a lot of frustration for Johnny. And I thought the whole discovery process was one long frustration, because we had to keep telling him, other than his deposition, and even at his deposition, just obviously answer the question you're asked. This isn't your time. You'll have a chance to tell your story. And I think it was enormously frustrating for him. His life had basically stopped professionally. Studios weren't returning agents' calls. He was living through hellish publicity, and his lawyers were saying, you can't do anything about it. So I think in that sense, the trial was paradoxically a bit of a release for him, because he knew that he was finally going to have an opportunity to speak. And I think he finally realized that we knew something about what we were talking about, because some things that we told him, and I've had this with other clients too, that during the discovery process, they kind of think you're just someone to whom they're paying bills. And as you say, they see it on TV, I could do that. I could ask those questions Tony's asking. But I think when they get to trial, it becomes a little more real for them. And when they see their attorneys functioning in a competent way, or relatively competent way, and what we told him is unfolding, I think it creates confidence in the client. And they begin to think, now I'm understanding what I was paying for. Now I know why they wanted to prepare me for so long. Now, they see the sausage being made, and then they see how it comes out. And even though, as Camille said, and as you know, it doesn't always come out the way you want, it often does. It does enough that the client is happier than he was during discovery, I think.
Right. Camille, I'm asking you this question because I've been practicing, 12, 13, 14 years, I don't know. And I know that it's starting to be, I can feel the difference from being a young lawyer to being a little bit more seasoned. And Camille, how do you handle, sometimes clients or witnesses, they size you up because of your age. And how do you deal with that? Even judges do it, opposing counsel does it. How do you handle that? Or do you feel like that's something you have to handle?
I love to be underestimated.
Me too.
I love it. Again, this goes back to over preparation, hard work, and just doing your job, right? I mean, look, we got a tremendous amount of recognition, but we just did our job, and we did it well. And, I think that you earn the respect of your clients by continuing to do your job, continuing to win, continuing to do a good job for him or her. And you sometimes get the opportunity to showcase that to the client or to the world in our case. But trust me when I just say it's nice to be underestimated, and it just drives me.
I understand that. I totally understand that. Ben, I'm going to ask you this question. I actually think I know Camille's answer. I think I heard it, although I'm going to ask her a second. Ben, when they do the movie, who do you want to play you?
I think Judge Reinhold.
Okay.
He's a goofy looking guy like me. No disrespect to him, but I think that would be the right guy.
I can see that. Camille, I want to hear what you said. Just curious, because I think I heard you answer the question. I'm curious if your answer is different.
Yeah, I mean, what's funny about this question is throughout the process, again, I'm spilling Ben's secrets, but Ben has a wicked sense of humor. It's part of the reason that I know I love working with him. But throughout this long case, he would periodically send out emails to the team especially when we got new team members, being like, okay, casting for the DeppVHeard case. So-and-so is going to play Camille, so-and-so is going to play the new member of the team. And I'm trying to remember, I think only because Penelope Cruz is actually a good friend of Johnny's. I think Ben had recommended Penelope Cruz. When I was growing up, some people said I looked a bit like Eva Longoria. I mean, gosh, I'd be tickled pink to be represented by any of these, beautiful, smart, captivating actresses. And gosh, I don't know.
I think we're just about almost done. So Camille, what would you say? Let's talk to young lawyers. I know that at the Beverly Hills Bar Association, one of the things that we always are trying to do is encourage young lawyers to become more involved, because that's the lifeblood. I feel like it's the lifeblood of what we do, is to have young people come in, and you showcase that in this trial. So speak to young lawyers, young people who maybe are thinking about becoming attorneys, or even just those in law school or just graduating law school. What advice would you tell them for the first, that they should focus on for, maybe the beginning of a career, or trying to start off a career like this?
Well, it's a lot of hard work. It's a lot of long hours, but it does pay off. I mean, there is no shortcuts, unfortunately, right? And it goes back to your question and the discussion we had about whether lawyers encourage their children to become lawyers. It's a hard profession, and it just requires a lot of hard work. But I promise that it gets easier. I promise certain things start to make sense. And I think watching trials, take as many opportunities as you can to, if you want to be a trial lawyer, right? Go to trials, sit in on trials, right? Watch how attorneys take depositions. You will learn so much. Sometimes you'll learn what not to do. And sometimes you'll pick up something that you can say, I can do that, or I can do it better, right? But learn by observing other lawyers and how they do it. I mean, I'm so grateful that this young team of lawyers was able to have this experience, because I can't tell you how many of them came up to me, especially my more junior team members, that said, I now understand why you said, we needed to object to this interrogatory request, or I now understand why we argued so hard for this discovery. And it all kind of comes together at trial. So my best piece of advice is work hard. It will get easier. Things will start to click and make sense. But there are really no shortcuts for this. This is a tough profession that requires blood, sweat, and tears, unfortunately.
Good advice. Ben, same thing to you. To young attorneys or those who are thinking about coming into the profession, what advice would you have for them?
I would echo what Camille said, and also to use any opportunity to get into court and to get into depositions. For me, I used pro bono, because the firm I started out with, and Brown Rudnick has a strong commitment to pro bono. As a young lawyer, it's a great opportunity to get more responsibility early, because just a fact of life in a landlord-tenant case, Catholic Charities case, you're not going to have 6 lawyers on it unless it's a big case. It's going to be a young associate, maybe lightly supervised by a partner. And I think it's a great opportunity to get into court earlier. Is pro bono, I think, is a great way to do that. It's not that the case is less important. To the contrary, it's probably more important. But the reality is younger lawyers get more of an opportunity. And going back to Camille's point, that those younger lawyers are going to do a hell of a job because they're scared to death. And I remember my very first case was a child custody case before a Superior Court judge, Judge Sullivan, and he wrote us hard. And we both grew up. I mean, Judge Sullivan ended up being a federal judge, and he ended up doing a lot of the huge cases you're familiar with. And it's a great way to cut your teeth. And once you've done a trial, a pro bono trial, or, big hearings, you're not scared. I mean, and I find, and I get off my soapbox, but there are a lot of people, even at big firms that who make a lot of money, who didn't take the opportunity. And so they find themselves as middle-aged and even older lawyers, and they're scared to death of the courtroom because they never did it when they were young. And it's too late to go back. If you're 45 years old and you've only been at one trial, it just doesn't work. So I would just say, seize the day, get involved in these cases, go to the partner and say, or go to a partner you admire and say, look, I really want to work with you. Of course, I'll do the document review, I'll do the scut work. But even some people who aren't that nice, if they see you working really hard, they're going to give you an opportunity. They're like, okay, I've seen you work that hard. You can take a deposition. So it'd be pro bono would be one thing. And then just really, as you all were saying, throw yourself into it and ask for the opportunity. Because it's not about money when you're young. There'll be money later on. Just get the experience.
And one of the things I learned quickly is that, which was great, when I went to hearings for the first time, I realized, oh, wow, everybody's behind me. You don't really see the people except for you're just talking to the judge. So it's not as daunting as you might think. I could do this all day. Thank you so much to Ben Chu and Camille Vasquez for joining us. This is the very first lunch with, and I really, really thank both of you. You really had a great conversation. Thank you so much. I'm Tony Ross, president of the Beverly Hills Bar Association. And thanks everyone for tuning in. Next time, I'll see you. Bye.
Thank you, Tony.
Thanks,
All right.
Tony.